Good evening, everyone. My name is Jim Wabandato. I'm a program officer at the Indian Land Tenure Foundation. The foundation has put together a series of town hall meetings for the education and for as a resource to tribal communities. Our goal is to help educate community members about various issues on land ownership and land management, as opposed to doing a webinar where we may have speakers who specifically are talking about a subject. They'll go through a very fixed presentation. My goal in presenting this as a town hall is to give you, the listener, opportunities to ask your questions, to perhaps find answers that will help you as well from other audience members. I do have questions to help get the process started, and I strongly encourage everyone to submit questions that you have that you'd like me to introduce to our two speakers today, our experts on various aspects of the probate process and probates in general. I will also quickly highlight that this is a regular feature. Our next meeting will address appraisals of right-of-ways, and that is scheduled for late in August. So please keep your eyes open and look for the information at the second Tuesday of the month, and then the town hall for that issue, the fourth Tuesday of the month. Having said that, I'll start with Peggy Carmack and have her introduce herself, going in alphabetical order.
Hi, well, good afternoon or evening in your part of the world. It's still afternoon here, 4 o'clock. So my name is Peggy Carmack. I work for the Bureau of Indian Affairs out of the Northwest Regional Office. I am the Supervisory Legal Administrative Specialist. I've worked in probate for a little over 20 years and had an opportunity to work in various parts of the country with multiple regions and multiple agencies. So I'm hoping that I can maybe answer some of your questions that you maybe have today. And thank you for inviting me, Jim.
Okay. My name is Stephanie Berghart. I'm Stephanie Hudson, and I am a member of the Kiowa tribe, and I'm the executive director of Oklahoma Indian Legal Services. I've been the director there 5 years, and I've been with Oils for about 25 years, and I have quite a bit of experience in representing tribal members who own trust Indian land and assisting them with drafting their wills and assisting them in reading their documents that they receive from the Bureau of Indian Affairs and helping them understand the land that they own, helping them understand what easements and such are upon that land, and then assisting them in understanding what would happen to their land if they were to pass away and the land passes without a will, and then helping them understand how the land would pass if they were to have a will when they passed away. And we represent all the tribes in Oklahoma. There's about 30 of the tribes in Oklahoma who we really do a lot of assistance with drafting wills of the trust Indian land.
Thank you, ladies. I appreciate your introductions. As I mentioned, I do have the ability for audience members to submit questions, and I can get them addressed to you. But I would like to start with a couple of basic questions in my book, but sometimes my basic questions might be a little bit different. So what is the difference between estate planning and probate? You often hear those two terms used together quite a bit. So what is the difference? And you guys can kind of jump in as you see to answer.
Let me go ahead and talk about the estate planning process first. What the estate planning process is something that you begin during your lifetime, and what we assist tribal members in doing is looking at the land and the other assets that they own, and starting to make a plan about what they would want to have happen with their assets when they pass away. And sometimes that's a difficult conversation to have with tribal members. Many tribal members are taught, really don't talk about death. That's not something good to talk about. But what we try to do is take it from a perspective of you have a lot of assets, you have a lot of land, and how do you want to care for it? And, we don't have to talk about death. We can talk about how do you want your family, how do you want your family to own it? Whether it's now or whether it's later, how do you want your family to own it? So we talk about what land they own. We talk about who their family members are. And we have a little conversation about who takes care of you, who helps you out with things, who has expressed an interest in helping you out with the land. How do you see your land being owned in the future? So we have those conversations with the landowners, and we help them draft a plan about how they want their land to pass when they pass away. And we do a will for them. And the will, we always tell people that a will is just the instructions to the judge. The will is the instructions to the judge about how do you want your land to either be divided, or who do you want your land to go to? And along with the instructions, we give them the option of thinking about some other documents that they may need. They may need a power of attorney that will allow a family member to help them make decisions should they not be able to make decisions during their lifetime, such as who do they want to take care of them, should they need to be in a medical facility, who can help them with social security and insurance problems. We assist them with an advance directive so that they can tell the doctors ahead of time, how do I want to be cared for if I can't speak up for myself? And if they want to do any sort of documents where they pass property to somebody else during their lifetime, if they want to transfer title during their lifetime, then we talk about what kind of documents they may need to do that. So estate planning takes place during a person's lifetime, and it's hard to get those terms straight and everything. But we do a lot of that at Oils.
So then to follow that, so probate, the difference is that probate is after one has passed.
Mm-hmm.
That's the legal process in which applicable tribal, federal, or state laws that affect that decedent, those are applied. It is determining who the heirs are. It determines the validity of the will. It determines whether any claims against the estate will be paid from any trust personality or money that is in an IIM account. And it also transfers, it's the legal document that transfers those trust or restricted ownerships to either the devisees or beneficiaries or other persons that are entitled to that, to receive them, so the heirs. So the probate process comes after estate planning. So that's, I think in outreach, that is the most important thing that we try to encourage landowners is to do the estate planning. Mm-hmm. And now more tribes and are involved in the estate planning process now more than ever. So we really do appreciate that. So that's kind of the difference that I see between estate planning and the probate.
Mhm.
Wonderful, thank you. In fact, in the process, my next question would have been, how does estate planning help the probate process? And I think you both have done a wonderful job even in catching that part of it. What should I consider the family's responsibilities in the probate process?
During the estate planning process, we encourage the person who's drafting a will. We encourage that person to designate somebody in the will or talk to family members after they drafted a will, and let the family members know that they've drafted a will, that they've made a will, that they have estate planning documents. And then we tell the person who drafted the will that they need to let the family member, they need to let a family member know where that will is, and make sure that they've designated somebody who's going to take care of the business of the will. And we don't go into a whole lot of it with that person necessarily about the details of that. We, like I said, sometimes death is a difficult subject with tribal members. So we tell them that you do need to let somebody know what's going to happen with the will and where you put the will. And we tell them that if that person asks, well, what do I do with the will? We tell them that they need to take it to the agency, and the agency will tell them what to do with it.
Yeah, I think that that's a big responsibility too, for someone to take that responsibility on, but it's truly an important step in knowing where those documents are, because BIA or probate is going to ask you for those documents.
Mm-hmm.
And so our responsibility, BIA's responsibility, is to gather in what I call the discovery phase. That's when someone reports a death. And so the family is really, you can rely on the agency or you can rely on the tribe to notify BIA that someone has passed. But really, if it's great if the family contacts us and lets us know, because they can give us some very important information right in the beginning that we don't have to seek out. So discovery, the discovery part of that is that once we receive notification, then we can begin preparing the case file for an administrative law judge, because that is the next step in which your case moves to. So we need to have very important specific documents in order for us to send the case to the administrative law judge. Those types of documents are usually birth certificates, marriage licenses, divorce decrees, wills, either original or certified copies is what we ask for. It's very important. And I state that because a lot of people don't want to release the will. However, you need to know and understand that an administrative law judge must see the original in order to use it in that probate case, because he has to determine that that will was never destroyed. They don't use copies. They use certified copies, or they use the originals. And by certified copies, I say that in a term, usually there are times when you have to use a will for more than one probate case. So you may have it filed with a state court, you may have it filed with a district court, like Stephanie deals with. And those courts will certify a copy of that will for our administrative law judge. So important documents such as that. Other documents that we do provide, we are able to get from tribal enrollment if individuals are enrolled. We can verify their enrollment. But the important ones are wills, marriage and divorce decrees, and adoption records if they're available, and of course birth certificates and death certificates of any family members. So that is what BIA works with you on, is gathering that information. So it's important that family contact us because we do need that relationship with the family in order to prepare the file in its entirety. The more complete the file is when it gets to the administrative law judge, the faster that case moves through the adjudication phase.
Those documents that Peggy was talking about, it's important that tribal members keep all of those documents in a safe place. One of the educational things that we've been doing over the past couple of years is educating tribal members on keeping those documents not only in one place, but in a safe place. And we've been working with FEMA to make sure that those important documents get put into Ziploc bags, into plastic bags, and then sealed up. And then we encourage them to put that sealed bag into a fireproof box. And make sure that that fireproof box is in a location where not only the landowner knows where they're at, but where their family members know where they're at. And that way, in case the family members need to access those important papers, they know that they're in that fireproof box in the Ziploc bag. There's been so much flooding and ice storms and such in Indian country lately that we get very concerned that documents are going to not just burn, but that they'll get wet.
Yes, that's important to remember, safe storage so that these documents are available for the probate, especially wills. I think Peggy hit a very important issue, which is if an original will cannot be produced, copies will generally not suffice, and therefore it would be as though the decedent, the person who's passed away, doesn't have a will, and that would be a shame when most people hopefully will have a good idea of where grandma or grandpa wanted the property to go. And so having those documents accessible but safely protected is so critical to the probate process.
We encourage our clients who we draft wills for, we encourage them not to make copies of the will because it's easy nowadays. Copiers are very sophisticated and sometimes it's hard to tell what the original is, and that makes it difficult for the Bureau of Indian Affairs or the Department of Interior to determine whether it's the original will or not. So we encourage them, as much as you want to give copies to all your kids, that it could cause confusion later on, and if possible, please don't make copies of the will, just keep the original.
It's good to know. Because we have you with us today, Stephanie, I think a lot of what we'll talk about tends to be centered on the federal probate process that most allottees will go through, but can you talk a little bit more about probates in Oklahoma, specifically as it relates to restricted fee lands, the 5 tribes, and other issues that go through a different process altogether for probate?
Yes, in Oklahoma, we've got the 5 tribes of Oklahoma, the Cherokees, the Choctaws, the Chickasaws, the Seminoles, and the Muskogees. And there are different federal laws that apply to those 5 tribes in terms of landowner ownership and status of the land. Those 5 tribes, they own their original allotted land. They own it in fee status. They have the title to the land, and they can sell it, give it away as they want. However, they have to get approval from a state district court judge. So where the land is, they have to go to that county, and they have to, if there's a probate that takes place, the probate happens in that county, in that state county district court, and the family has to pay filing fees and has to hire an attorney quite often in order to go through that probate process. That's quite different than it is with trust Indian land, where the Bureau of Indian Affairs, the Department of Interior will almost, take the whole process through for the landowners, so that the landowners, it gets probated. With the 5 tribes, the family members must take the initiative to get the land probated, or it never will get probated. And we see a lot of issues in Oklahoma with land titles that are very much not brought up to date, because no family members have been able to afford getting the probate done. It's not a matter of whether they want to. Many of them want to, but it's a matter of whether they could afford the attorney, afford the filing fees. So that's where Oklahoma Indian Legal Services comes in. Is we provide the free legal services in order to get the title work done, get the probates done. And we have agreements with several of the tribes where the tribes will pay the filing fees for the tribal members in order to assist them in getting the titles brought up to date. It's a very similar process in terms of the process and procedures that happens with the trust Indian land. It's complicated by the fact that you have another jurisdiction slid in the middle of that, the Oklahoma state courts, where all of that takes place.
Thank you. And if I'm not going to misspeak, that is the Stigler Act of 1947 that set up the process?
That's the Stigler Act of 1947, and there have been some amendments to that. Previously, the land could pass only to members of the 5 tribes who were at least 50% of any of the 5 tribes. And then once the land passed to somebody who was less than 1/2, then the restrictions fell off. In 2018, there were amendments passed to the Stigler Act that eliminated those blood quantum restrictions. So now the land may pass to any family member, and the restrictions will stay on it. It's very good for the tribes. It will keep more of the 5 tribes' land in as an Indian country status.
And that also applies to the 3 Creek tribal towns as well as the Kituwa, is that correct?
Yeah, a lot of their land, it lays on top of the 5 tribes' land, so a lot of their jurisdictions are similar. So usually that would also apply also.
And I do want to reference, because this was not included in the information I sent out at the beginning of the month, but there are, in addition to the Stigler Act, which affects then 9 different tribal jurisdictions, as it were. Osage falls outside. They have their own probate act by Congress, and there are, let me see, so that would be 10. Then there are 10 more tribal communities in Indian country that have either affected their own probate code under the American Indian Probate Reform Act, or have had previous probate acts passed by Congress. So there are about 20 tribal communities in Indian country that do not follow the American Indian Probate Reform Act.
Yes, and I would encourage more tribes to really look at enacting their own tribal codes, and that there's many different creative ways that tribes can do that. And I would really encourage tribes to get with Jim and the Indian Land Tenure Foundation if you're interested in drafting your own tribal codes, probate codes.
The one question I do have, either for Peggy or for Stephanie, is that the Osage is a congressional act. Are they subject to going through the Oklahoma State Court, or only the Stigler Act affected tribes?
We take those cases through district court. Peggy, have you been have you had experience with the Osage probates?
I have not, no.
Okay.
No.
Yeah, we take those, but they deal with their head rights in a different manner, and they draft legal documents at the tribe to deal with their head rights.
And Peggy, correct me, I believe then the other communities such as like Sisseton, Wahpeton, the Lake Traverse Reservation, Standing Rock, Yakima, those go through the Federal Office of Hearing and Appeals, is that correct?
Correct, they do. Yeah, so a lot of those congressional acts were done for the Northwest tribes, the Yakima, the Warm Springs, the Umatilla, and the Nez Perce all have had congressional inheritance acts, and they, but they impact a probate, but they still go through the federal American, the APRA regulations. So they still go through that, but they add a separate function to the probate then as well. So it's another phase of probate when those are involved in the probate process.
So to clarify then, are you what, I guess, are you saying that they follow APRA's distribution standards, but maybe slightly modified by the Tribal Act?
Well, the distribution is the same, but the act, some of the acts, for example, the inheritance acts in the Northwest region for those tribes that I mentioned, they have their first right to purchase those interests from anyone not a member of those specific tribes with a 1/4 blood quantum. So the tribes actively participate in so the heirs are still determined through APRA, but then the act allows the tribes to purchase those interests from those heirs. Does that make sense?
That does help, actually.
Okay. Yeah. So that, to clarify, it's not, you know, it doesn't change the distribution through APRA, but it does allow those tribes to maintain or retain their reservation lands from non-members. So if they actively purchase, not all of them actively purchase and they allow it to pass as long as it's going into trust, but there are ones that are very actively purchasing through probate.
Okay, thank you.
Mm-hmm.
I say this partly tongue-in-cheek, but it is probably the way that we hear the question so often. Why do federal probates take so long?
I knew that question was coming. Well, there's a lot of things that impact why they take so long. One of the things, of course, is the amount of probates that need to be done. And not always is there resources to work on those cases. We have limited resources. If we had enough people to work on those cases, we could probably move them along a lot quicker. But there's a lot of variance that goes into probate. One is that not all heirs or potential heirs are enrolled members of federally recognized tribes. So therefore, agencies or gathering those important documents that we need are not as easy as we would like them to be. So that means if a tribal enrollment office can't provide us those documents, then we have to go outside that and get them from the family directly. And individuals who are not enrolled or not affiliated with agencies are a lot harder to contact. There's no information there. Some of the other things that impact or take the time for probate, excuse me, are exactly the inheritance acts that we were talking about. Those inheritance acts require that prior to submission to the Office of Hearings and Appeals, that those interests subject to purchase be appraised. And so we have to go through the appraisal process for those interests if there's a potential heir where the tribe may be able to purchase. So we have to acquire those documents. What does that mean? Appraisal reports may not be just that simple to write. They may take a little bit of time. We have a lot of resources on the land that has to be appraised appropriately. Timber takes a different direction. There has to be a timber cruise done for that information. So it all adds time to the probate. That's why in the beginning, that was a really good question that you asked about family being involved. And if family is involved and they help us acquire that information, we can move those cases along a lot faster if we do not have to be the detective and find the information. So there's a lot of variables to probate, and there's a lot of things that happen within the probate process itself. We've had systematic changes. We've had, staffing changes. That's just kind of ongoing all of the time. So when systems go down, things stop, the wheels stop, because we can't gather a lot of information in these databases. And if they're not available and they're not working up to standard and we're not able to process things, then that slows things down. So those aren't excuses. Those are real truths of things that do happen. We do try, I know, on our side, we do try to get those cases out. We do tend to try and work on the oldest cases first. However, we also work with families that are willing to work with us and help us get those moving if we possibly can as well. So hopefully that gives you kind of a little bit of an idea of some of the things that we come across in the probate process that delay it and add that time.
Thank you, Peggy. I've got a couple of follow-on questions to that, but before we move ahead, Stephanie had used a term that is unfamiliar to other parts of Indian country. Can you give us a little bit better explanation of what head rights are and what that means?
Yes, I'm going to explain the best that I can, not being Osage. Osage, the Osage Reservation is a large piece of property in northern Oklahoma, and the Osages made the decision that the minerals underneath their land, they would own it together, all together, and as people passed away, the interest would stay all within the tribe. And and Osage County is, and you will learn this winter with the new movie coming out, Killers of the Flower Moon, or a Gray Horse, that there was a lot of oil underneath Osage County. And what the tribes decided to do was they would own it together, and then as it produced income, then that income is divided out based upon the number of head rights that a person owns. and those head rights can be given to other family members. They inherit them from other family members. So it's not necessarily owned communally and they all share it communally. It's that the tribe owns it, and then the shares are distributed by the owners of those head rights. So each person may own a different amount of head rights based upon how much they were either given or left to by their family members.
Thank you. So kind of jumping back to related questions, one of the issues that came up in the comments during registration from one of our tribal communities is there consideration to completing mass appraisals for probate purchase? That it may help to address the backlog that's occurring because regular appraisals do not seem to be completed in a timely manner?
I believe that there has been discussion, and I'm not an appraisal expert, so please, but I have been involved in discussion about it. And there's a specific standard appraisal that the Office of Hearings and Appeals needs in order to process the probates. And it has to meet what's called a USPAP standard in the appraisal community. So, but the mass appraisal function provides a more restricted type report, and that's not used or that's not necessarily the right valuation for some of these interests. You have to understand that the reservations have different types of properties. Some of them are, you've got the Yakima Valley, who is agricultural, so it's there's a difference there in the crops that may be growing that's on the property, or something that may impact that. So for right now, the mass appraisal approach for probates is not something that we're able to use, but I know that they're looking into something that would suffice for that process. I actually see one of the appraisers on here who knows a whole lot more about appraisal and mass appraisals than I do, which is Eldred. He might be able to answer that question. Not to put you on the spot, Eldred.
Would you be willing to answer that?
Yeah. Yeah. The mass appraisal process for probates, yes, it's been under discussions, and I think the last thing where we left off was a discussion with the Office of Hearing and Appeals for the acceptance of the methodology. It is USPAP compliant. It follows USPAP standard 5 and 6, and it is also IAAO compliant too as well, which is the standards for mass appraising. They do provide statements of value, and that's where the issue was, is the statements of value, like Peggy mentioned, are abbreviated reports. The analysis of the data is extensive, but the reporting under a mass appraisal is limited. However, the information in the analysis can be converted to a more narrative type report if needed. And if there's a situation where there's a complex property, like Peggy mentioned, where there's multiple types of properties involved, partial interests, and other types of complexities involved, the more than likely a site-specific valuation would be done. And a mass appraisal would not be the methodology, because mass appraisal is good for properties that are similar, non-complex. There's abundance of market data for it to analyze. And so it's got a limited scope as to its applicability. So, but it is a useful tool. Like Peggy mentioned, it's cost effective and efficient. And yeah, it's a matter of just AVSO and OHA coming together to come to terms on the use of mass appraisals.
Thank you, Eldred. I greatly appreciate you adding that to our conversation. If I'll shift gears then, between Stephanie and Peggy, what impact has COVID and working from home, the different aspects of the pandemic, had on the processing of probates this last year and a half?
I'll let Peggy start. Yeah.
Yeah. Well, it took us from paper files to electronic files in a real big hurry. So I have to say that that I'm really proud of the way that our probate staff, not only in our region but other regions, was able to adjust to telework. And so we may have slowed a little, but we really adapted quickly to the telework process and working just with electronic files. Now, that doesn't mean that doesn't take us back to the office where we have to get the paper or look at the paper file, but it does allow us to work on something fully electronic file within our system and keep us moving. Now, it did impact some tribes more than it impacted BIA. Some of the tribes were hit very hard with, as you know, and very aware of, there were a lot of COVID cases on the reservations. And so some of the tribes were shut down for quite a while, and they're just now starting to ramp back up. But for BIA, we transitioned into electronic files, I think faster than we thought we could, because we've always had the hard copy file available to work from. So it's impacted us some while we went through the transition, but we've definitely picked up steam now and are moving forward again. And a lot of the tribes also that work with their probates are coming back online. But it did set people back a few, at least a year in the workload. So they're trying to overcome that as well as moving forward.
Where we're seeing an impact is with our clients who want to be able to get information regarding their land. If they want to draft wills, usually we ask them to contact the realty office or even the fiduciary trust officer to obtain an inventory of their trust assets, or information that shows who are the leases, what are the leases on their lands and such. What our clients are reporting to us is that they're having a more difficult time obtaining those documents. Our tribal members are very accustomed to just going to their local agency and being able to obtain those documents. And a number of our clients, they may use use mobile phones a lot, and sometimes they don't have the minutes to remain on hold, or connectivity is a real problem in a number of locations where our tribal members live. So even if they are given a telephone number, they may not be able to get cell phone service where they live, and they'll have to drive into town in order to get cell phone service, in order to be able to call the agency to be able to talk to somebody about getting the documents that they need in order to get their wills completed. So we do appreciate the fact that we've been able to talk to Bureau of Indian Affairs employees who are teleworking. One of the things that our office may be doing is contacting some of the superintendent's offices and ask them, is there a way that, you know, there can be a counter open with COVID protections, precautions, or something for you know, quite a few tribal members who aren't comfortable on the telephone.
Okay, thank you. One of the last questions I have on here, when I shared information with my email group, I talked about the fact that there were proposed regulatory changes. For those of us who've been in Indian land and probate and estate issues, I think we've been kind of waiting for these things to come online. And I highlighted overly burdensome purchase at probate. I had highlighted increased opportunities for renunciation to maintain trust status of the property, reopening closed probate cases, streamlining the process for small estates, and descent of off reservation lands. Are there things that you feel are important for people to understand that those regulatory changes will have on them and their families? They could maybe the issues I highlighted or other issues that you're familiar with. What would you say about those proposed regulatory changes on probate?
Well, I can speak to the purchase at probate process. The change for purchase at probate will currently comes in at the hearing. So at the hearing, if a tribe has submitted a letter of intent or interest in purchasing the interests that are in that estate, it kind of holds up the estate at that point, because then is when the appraisals have to be done. This is different than the Inheritance Act purchase that we're talking about. This is for the less than 5% interest, or typically the less than 5% interest that the tribes have been notified through the probate process are in that estate. So the regulatory change will move that process from the middle of the probate or at the hearing. The tribe can extend its interest in purchasing, but the purchase will happen at the end of the probate. So the heirs will be determined, but it'll just move further down, so it does not just stop the process of the estate until the appraisals are received. So that regulatory change will help at least move and determine who the heirs are for the estate a little quicker. Also, one of the regulatory changes the amount that you will be able to acquire from the estate account versus, I think, $1,000 currently to $5,000 for help for death benefits, if that exists in the IIM account at date of death, to help families in the burial situation. And then the small estates, typically small estates or summary estates that are less than $5,000 can typically go through an administrative law judge or attorney decision maker without a formal hearing. As long as the record is complete, they can determine who the heirs are if there's no trust property and money only. Well, some of the money only estates are less than $5, and they still have to go through that same process, whether it's 2 cents or whether it's $5,000 or whatever. It still has to go through that same process. So they are trying to develop a process for those estates and those small dollar estates to help those process a little quicker than the complete probate process. So what that actually is, I don't know yet until those changes come about.
Stephanie, did you have anything within the changes that you'd like to address or help educate? You're on mute, by the way.
I was busy reading the chat. No, I'm not familiar with those changes. I enjoyed listening to what Peggy had to say about those.
Thank you. That's okay. One of the questions in the chat is about the status of structural improvements. Let me move it in front of the camera. Is there a possibility that structural improvements and other land improvements would be regarded as part of the real estate rather than be regarded as personal property? And that is actually something that has been a very important issue at the Indian Land Tenure Foundation. I'm not sure if we quite have the right audience, so I'll take a quick stab at that from the foundation. One of the things that we were looking at is perhaps getting it modified to reflect restricted fee status rather than personal property status. As personal property, the improvements, so structural improvements like houses, fences, barns, other things that generally prior to the 2008 change to APRA made permanent improvements considered personal property or not trust assets. There were a number of reasons for doing that. If it should be changed, in our opinion, or at least in my opinion here at the Indian Land Tenure Foundation, to restricted fee status, the title actually goes to the individual, and it would be much cleaner in keeping those consistent with the underlying real estate asset. Again, there were financial and regulatory issues that were considered when Congress passed that amendment to take it out from underneath ownership by the federal government. Without getting into too many more details, to us, changing it into restricted fee status could potentially give it that, keep the protections that the federal government was seeking while providing, again, consistent ownership, because it would be not quite a trust asset, but it would be a federally managed asset with restrictions on passing amongst title. I don't know if this is an issue that either Peggy or Stephanie has come across.
Well, it's my understanding that so BIA does not have title records of any permanent improvements. So we do not know the ownership of those permanent improvements, or we do not monitor or regulate or record any of those. So that in there lies the difficulty on determining who really owns those permanent improvements if there's no title to them. So that I would just make that statement. I think that's where it was difficult because the underlying land may be, shared by many. And so it's, so that would be the only statement that I would have. It just that we do not know who the owner is, and we cannot confirm who the owner is. So in my perspective as a probate person, where I have to assure a judge that ownership is what it is for the estate. So I have to tell him, I have to provide him a certified inventory of the ownership of the land of an individual, of the decedent. And I have to provide him a IIM ledger that accounts for the ownership of the IIM account of the decedent. I don't have the title document for any permanent improvement to assure that the judge has authority to pass that to his heirs. And I can't get it because I don't have it. I don't have it. We don't have it in our system. So that in there is one of the problems that comes about.
And that's really been the crux of the problem that the technical amendment created.
Right.
Common law would have dictated prior to that, and general United States law in regard to real estate would say that these permanently attached, permanently affixed improvements are part of the realty. And so it would be consistent. It would be exactly the same. Once they passed that technical amendment, absolutely, it created confusion for individuals, for interior, for the tribes. And so there is no consistent way to manage that.
Right.
Reattaching them through something like restricted fee might continue to be a Herculean effort, but I believe it is something that does need to be addressed to help straighten out, again, and I'll be blunt. I tend to feel at times that some of the solutions that are developed by Congress or through regulations help to address problems for Washington, D.C. in managing Indian land. It doesn't always work out well for individuals who might be in the Indian communities. And this is another one of those that I would say falls under that umbrella. We are at the end of our hour, so I do want to give Peggy and Stephanie each a few minutes if you would like to close, as well as any parting shots about probate, the probate process that you want to remind folks that are important to remember.
In terms of the estate planning process, I think it's important for tribes to encourage their Indian landowners to start the estate planning process early. It's sad when we have a landowner come to us and they've been wanting to do a will for quite a long time, and they've reached the point, especially this past year, where they're too ill to be able to get the will executed, or family members know that, oh, mom has always wanted to do this with the land and she just never got to get it done. So I think it's important that the tribes provide opportunities for their landowners to be able to get the wills drafted. Like I said, I work with Oklahoma Indian Legal Services, and there are Indian Legal Services offices throughout the nation who can assist landowners with getting their wills done. There are many attorneys who understand how to go through that drafting process and execution process.
And Peggy, last thoughts as we wrap up?
Just to encourage family to work with their local agency, tribe, or probate office, whoever is providing that service for them, in gathering the information needed for their estates. The more the family contributes, the more the quicker we're able to process the estate, and that, that, and I look forward to some of those regulatory changes as well, and hope that they help streamline some of our processes, because I do realize that they are cumbersome. And we also do recognize that through probate is usually many times the first time an individual becomes a landowner. And so I just encourage them to, learn as much as they can about the land ownership, because there are so many people who do not understand, undivided interest and how it impacts them and what their ownership is, and what is going on with it. And it's important for them to know. So I like the outreach. I definitely like the outreach to the landowners.
Thank you, Peggy. I appreciate your time as well, Stephanie. And I especially, that last comment, Peggy, you reminded us that, yes, through probate is when most Indians become landowners. And so the Indian Land Tenure Foundation does quite a bit of outreach to help educate landowners about what their responsibilities, what their opportunities, and what their rights look like. We'll continue to put these on through the rest of this year and look forward to putting them into next year. As I mentioned, on August 24th will be our next town hall. We will be addressing the appraisal of rights of way specifically. And I encourage people to keep an eye out for information on that. If you do have any other issues or questions that you'd like the Indian Land Tenure Foundation to address through this series of town halls, please let us know and send me an email. I will be getting out an evaluation for everyone to fill out shortly within the next couple of days. And I look forward to hearing your feedback on this. Again, thank you so much, Stephanie and Peggy, for joining us and helping us address these issues tonight.
Yep.
Thank you for the invitation.
Yes, thanks.